March 24th of 2022, and we are here for a special town board meeting and a CDA meeting, which will immediately be followed by a regularly scheduled work session. And as always, we're going to start with the Pledge of Allegiance. Tim, can you please take the lead?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Tim, and we'll now open it. We're going to open up the meeting for public comment on a town board resolution before us this morning. And is there anyone who wants to comment on it? I think we should read the resolution before.
Larry, there's a little bit of feedback up here.
Yeah.
Okay, you want it read?
You know what? Then we have to read it again, but it sounds weird, come up and nobody knows what they're talking
That's
about.
fine. Town Board Resolution 2022-246, a resolution authorizing the Town of Riverhead Community Development Agency, the CDA, to make joint application with Calverton Aviation and Technology LLC, CAT, to the Town of Riverhead Industrial Development Agency, IDA, to transfer title to all of the acreage CDA owns at the Enterprise Park at Calverton, known as EPCAL, compromising approximately 2,100 acres in order to facilitate the sale and transfer of approximately 1,643 plus or minus acres at EPCAL to Calverton Aviation and Technology LLC, CAT, pursuant to a lease and project agreement by and between CAT and IDA and consistent with terms of the agreement of sale between CDA, Town of Riverhead, Town, and CAT dated November 19th, 2018 agreement, except as amended and agreed to as set forth and reflected by the terms of this resolution and letter agreement between the CDA and Town and CAT, and agreement between CDA and IDA for transfer of the remaining property. And that is probably the longest sentence I've ever read without a period in it.
Anne Marie must have written it. She's great at it. She's good. All right. Does anyone want to comment on the resolution before us today?
Madam Supervisor, before we begin, I'm just going to remind everyone that pursuant to the town board's adopted rules, each person speaking is going to be limited to a 5-minute time period. When you have about 30 seconds left, I'll sort of wave at you and take it from there.
Good morning.
Good morning, Madam Supervisor, gentlemen. Rex Farr, farmer, Calverton, EPCAL Watch coordinator. This morning, I'm here to simply remind you that EPCAL Watch is going to be watching. We are still standing after 5 years of bad behavior, stupidity. We are going to monitor very closely the actions that you are about to vote on. My colleagues will be very specific about what to expect out of you, the board, and the deal. And we definitely want you to do due diligence. Finally, I would appreciate that, and I've been asked to say that, please schedule the next meeting where the majority of your constituents can attend. Thank you.
Thank you, Mr. Farr. We did have a public forum. It was open in the evening. It was consisted of over 3 hours of total participation. We had all the members concerned here. Every question was answered. It took place prior to the resolution being put forward in this town, and we will continue to have an open process. And thank you, Mr. Farr.
Madam Supervisor, if I could just add that I know that Ms. Prudenti in my office has continued to field questions since the forum.
Yes.
And also the last town board meeting, you allowed questions as well and comments on this particular resolution as well.
And today, you'll have 2 opportunities before this resolution and at the end on any other comment, concerning any other comments. So, good morning.
Good morning, everyone. My name is Sid Bale. I'm president of the Wading River Civic Association. I'm also have been authorized by James Lorenz, the president of the Jamesport Civic Association, to make the following statement. We fully understand the importance of this special meeting. What we don't understand is why this special meeting is taking place at 9:30 in the morning, a time in which makes it impossible for most town residents to attend. We also don't understand why more time was not given to the public to review this resolution. It would also have made sense to have had this resolution available at the March 8th forum the town conducted to explain the transfer of property to the IDA. We believe the best course of action for the town board is to table this resolution and reschedule to a time that gives the public an opportunity to participate in the process. We respectfully ask you, table the resolutions, reschedule the meeting. Thank you very much.
Thank you.
Thank you,
Have a
Sid.
good day.
Sorry, Russ Farr again. I forgot to mention who I represent and EPCAL Watch. You're talking to at least a dozen environmental groups from local to national, from the Pine Barrens to the Audubon Society. We're talking about our neighbors, and we're talking about civics. Sorry, thank you.
Okay. Good morning.
Thank you. Phil Barbado, Jamesport. I'm sad this morning. I'm sad for you. I'm sad for my fellow citizens. I lost my mom in early January, and losing your parent really brings home the fact that life is short, and you've got to do what you can, the best you can, to pass on good memories and good deeds. And I hope that you all can do that with respect to the EPCAL property. I tried to read. I went to the forum. I tried to read all the material. I listened. I asked questions. But I think this is still a long and very complicated new version that appears to have all the weaknesses or more than the current agreement. It still has no deadlines that are enforceable or that prevent transfer. There's nothing to prevent subleasing by CAT the day after we lease it to them. There's nothing that says the fee title is transferred when CAT files the subdivision application, not when they receive approval. So they can file any piece of junk they want and still get fee title. There's nothing to prevent CAT from selling the entire 1,643 acres the day after they get fee title. And they've done this before, you know that. I'm sure you know that CAT will seek every tax break available and probably get it. Where will all the tax revenue come from then? They've done this all over North America and Canada. They have a track record, and I think you're aware of it. I don't think you've done anything with it. So please, can someone of you on the town board please explain to us in plain, non-legal, non-technical English how this new scheme is better than the existing one? To us, it appears to be a complicated extension of this long, non-productive road to nowhere. A 5.5-year blockage in our journey to economic development. So I'd appreciate it if you would please explain it so we can understand it.
Anyone else? I'll call that at the end.
Good morning, Madam Supervisor, members of the board, ladies and gentlemen. My name is Barbara Blass, and I live in Jamesport. First, I'd like to thank you for authorizing that forum and for the preparation of the flow chart. That it was a very informative evening. I want to especially thank Frank, Anne Marie, and Dawn for pulling that all together. There was a lot of information that was given to the public. But in light of the fact that the resolution and the letter of agreement was not available then, and we now have an opportunity to read what those documents say, it's prompted a few additional questions and concerns, and I will respectfully just submit a few of them in hopes that you'll take them into consideration today and during the development of the application as it advances to the IDA if it gets to that point. So the letter of agreement states that in the event the IDA fails to issue an authorizing resolution, the seller shall have the right to declare the agreement of sale null and void any time thereafter. That really leaves the door wide open for this situation to continue and really doesn't accurately reflect the position that was publicly stated that under no circumstances would CAT be allowed to come back to the town of Riverhead. I think the supervisor you mentioned, not on my watch. This kind of leaves that open, and I'm wondering why you would agree to such wishy-washy language instead of terminating the deal by resolution immediately if the IDA rules in that situation that way. Resolution 246 states that CAT has expressed a willingness to agree to assume pursuit of the subdivision. Wishy-washy language again. Are they or are they not going to pursue the 8-lot subdivision, and under what parameters? The town will not get fee title back to its property until the subdivision is filed. Oh boy. Is the leaseback arrangement for the town purpose lots valued the same as fee title ownership of the CDA's balance sheet, on the CDA's balance sheet? And by the way, I apologize if there is any overlap in answers to any of these questions. I don't think there is, with respect to the information that was given at the forum, so I'll apologize in advance if some of this may have been addressed. In addition to what's reflected in the finding statement, the resolution indicates that in accordance with the CHIP, CAT will be preserving and maintaining 1,000+ acres it is acquiring. Is CAT going to be responsible for maintaining those acres during the lease term prior to acquisition? What is the legal mechanism and nature of the financial commitment required to maintain those lands in perpetuity? This was also mentioned in the agreement of sale in the context of a possible taking permit. However, the DEC's Part 182 regulations and enforcements were recently nullified by the court. Who then will be responsible for oversight of the preservation and maintenance of the sensitive habitats under these new circumstances, the IDA? The agreement of sale contains several covenants which were to be referenced in the deed and or contained in separate documents to be executed at closing. Will all of those same covenants be executed and binding at the time the lease and project agreement is signed? And just to be clear, is it your position that no further seeker is required until final site plan? That's what I believed I read in the documents. I reviewed a completed application for a financial assistant that was posted on the IDA's website, and it's very thorough and includes project description, costs and financing, project benefits, employment data. This is for another application. This kind of information should be made readily available to the public, as this involves redevelopment of public property under urban renewal. However, on the first page of the application, it states that the information provided in the application will not be made public by the agency prior to the passage of an official inducement resolution. The CDA is co-applicant here, and the uniqueness of this arrangement begs for full transparency at every step of the process. The resolution states that as long as the 1,000+ acres are subject to a lease and project agreement, public access will be subject to restrictions set forth in the agreement. Will the public have the opportunity to comment on those terms and restrictions the IDA will be imposing on us prior to the approval of the agreement? I thank you very much for your time and attention and consideration.
Thank you, Barbara. Anne Marie, can you just come up forward? And then we'll take Zoom. we'll take Zoom, just to give a little bit of overview on some of the questions.
Morning, everyone.
Morning.
Good morning.
So I'll just try to address as many as I can. So with respect to the language regarding the town board may deem the contract null and void, the language may is required because it requires a legislative act. So we cannot forecast what the vote would be with respect to a resolution in the future to determine the agreement null and void. It would require a resolution, you all have a vote. Next, with respect to the language in the whereas clause regarding willingness and agreement to assume the responsibility for subdivision, that's a whereas clause. The resolve clause makes clear that in the joint application, that will be a requirement and a condition as part of the joint application. Next, with respect to the IDA processes, it's my understanding that the IDA will hold a public hearing. And at that public hearing, the public gets to have input and ask questions. With respect to our preparation and joint submittal of the application, do I anticipate that that would be made available? Yes, it's a public document prepared in part, at least, by the town on behalf of the CDA.
Great, thank you. And Chip, do we have someone through Zoom? Okay. Okay. Can you hear us? Good morning.
Good morning.
Good.
Good morning, Tompkins Church in Calverton. I'm joining you today on my phone on Zoom because this 9:30 in the morning special meeting overlaps with my work, and I'm getting a special moment here, so I'm going to take advantage of it as best as possible. I've been asked by another person who couldn't attend today, either in person or on Zoom, Angela DeVito, to read two statements. I believe they're questions. So here I go. She said, Angela DeVito says, usual applications to the IDA for its development inducements suppose the applicant is the landholder. When the IDA acts on an application, an inducement resolution is passed, and then contract negotiations proceed until closing. And here's her first question. Is the CDA the development landholder applying for an IDA inducement resolution and subsequent contract? And is the CDA private partner, CAT, actually just a project manager developing the land on behalf of the CDA? And her second question is directed from the forum that thankfully you scheduled at 6 o'clock in the evening. It was very informative and helpful. And before I read it, as a result of that, a request was made, I believe I made it, for the resolution to be put up on the website for us to be prepared and read. And I thank you very much for preparing us in that way and having it up on the website as soon as possible. I look forward to that happening for our town board meetings as well, for all resolutions. So here's the last question from Angela DeVito. At the information forum, Don Thomas was asked to provide the legal basis, excuse the phone in the background, and background for our IDA being able to entertain an application such as the joint application proposed. To date, no information has been provided to Angela DeVito, who raised the question. When can she expect to get an answer from Ms. Thomas? Thank you very much.
Anyone else? Okay, Diane, please call. Oh, Mr. McAuliffe. There wouldn't be a meeting without you.
Exactly.
You
Have
know?
to make your day.
Yes, good morning.
John McAuliffe from Roanoke Landing. I want to do a little bit of forensics about the resolution itself, or not the resolution, but the agreement. Because I think part of our problem and the reason that we hope that this will be tabled again is that we don't understand why it is coming up in a special meeting rather than as part of a regular board meeting. What is the 5, 7-day or 8-day difference that's so important that it has to be now? We'd be interested in knowing the origin of this text of the agreement, how much it is was created by Mr. Eisler, how much it was created by Mr. Kent. We'd be interested in knowing, there was a news story that the supervisor that you rejected or postponed a decision on this because of language that the CAT was not coming through on, and we wondered exactly what that language was and how it was resolved favorably. I think we are somewhat disadvantaged by the fact that the agreement was not available at the time of the forum, that we think it does need strengthening, and it would have been more possible to strengthen it in the context of the forum discussion. We do think that, and I have been in contact with Ms. Prudenti about the process, as she said today, that this application will not come back to the board and will not be specifically voted on by the board, that it will follow the tone and content of the resolution. But we think that the actual application should come back to the board, that it's a different question to say that the IDA meeting is open than it is that in a board meeting where elected officials are responsible for making a decision, that the actual application is discussed, because the application should clarify some of the questions that people have. I want to emphasize, as was referenced earlier, that I think the problem of what prevents, and during the forum I asked this question, and there is apparently nothing that prevents the Germasians from flipping the property, given their financial situation. That would seem to be a real risk, and we don't know if there's something that can be put into the agreement that would prevent the property being either subleased or sold immediately upon them taking possession of it. As I said at the forum, I think the question of why the 1,000 acres is still in, since you had to rewrite some things in the agreement, why you didn't simply take those 1,000 acres back, which nobody ever paid for. So I think that also should be subject to revision of the agreement. The other point is a brand new one, and I will send the documents to you, but it is a complicated one, and I don't know what the implications are of potential conflict of interest. The 555, the Germasians, are being sued for spoliation. That is, that they have destroyed or are withholding evidence on the suit that has to do with the phony sanitizer. The company, the law firm that is bringing that suit is the law firm that the Council of IDA is a part of. I don't think he's specifically involved in that suit against Cat, or against 555, but his firm is involved in that. I don't know what the implications, and I think that's another reason to hold off on proceeding on this resolution today, that it should come up at a regular board meeting, and if possible, the actual text of the application should be provided, rather than that being something that, or if not provided, that the board put into the agreement that it is going to actually act on publicly and vote on the text of the application.
Right, that's about 5 minutes. Mr.
Okay,
Farrell.
fine, that's it, thank you very much. So again, the question on the sources of the document would be worth, and the question of what was corrected would be very useful to know.
Thank you. Anyone else? Chip? No one? Okay. Any questions? Okay, Diane, can you please call the vote?
Certainly. Resolution 246.
A resolution authorizing the Town of Riverhead Community Development Agency, CDA, to make joint application with Calverton Aviation and Technology, LLC, CAT, to the Town of Riverhead Industrial Development Agency, IDA, to transfer title to all of the acreage CDA owns at the Enterprise Park at Calverton, EPCAL, comprising approximately 2,100 acres in order to facilitate the sale and transfer of approximately 1,643 plus or minus acres at EPCAL to Calverton Aviation and Technology, LLC, CAT, pursuant to lease and project agreement by and between CAT and IDA, and consistent with terms of the agreement of sale between CDA, Town of Riverhead, the town, and CAT dated November 19, 2018, the agreement, except as amended and agreed as to set forth and reflected by the terms of this resolution and letter agreement between the CDA town and CAT, an agreement between CDA and IDA for transfer of the remaining property. So moved.
Seconded.
Vote, please.
Kern.
Yes.
Rothwell.
I just want to say that I think that at this time, I know this is a complicated deal all along, but I think this is the moment of truth, and I know their attorney is present here, but for me, this is a deal that was inherited by us, and I never liked the initial deal. I don't like it, but I think this is the moment where we can say it's time to put your money where your mouth is. So if you've got the money, the town could benefit from it, and we could be able to move forward. I don't think we're going to get our subdivision for many, many years, and I think that if we tried to go out of the contract in any other way, we're talking about at least 5 years of litigation, and it's not necessary. I do firmly believe this is the best way to move forward, and so that, and this money would certainly benefit the town in many, many ways. So I vote yes.
Bayrock.
Yeah, I'd like to thank our attorneys, Anne-Marie Prudenti, and head of the CDA, Don Thomas, and of course Frank Eisler, because this is a complicated matter. I think in the end, though, that they helped not only the community get through a lot of the questions, but certainly the board, and we leaned on you quite a bit. I agree with Kenny. I'd like to see a final end to this one way or the other, and I think this is the way to do it. So I vote yes.
Hubbard.
This is complicated, and I do, at the end of this, see a finality. And the finality could be a couple of different solutions. That's yet to be seen. But I think the opportunity that this provides us for some finality is more important than anything else we've done in regards to EPCAL. I think this is the proper way to go about it. I think it gives another set of eyes to it. It makes them put up or shut up, and either they can or they can't. And if they can't, we move on. If they can, then we do our best to make it the best it can be for the town of Riverhead. And the idea is to sell this property, as it has been from day one, as an economic generator, and that's exactly what this is all about. So I vote yes.
Aguirre.
This is one of the avenues this property should have taken many years ago, and unfortunately, in the past, it has not. It has been well-researched. I have met with different types of attorneys, the special counsel, the IDA attorney, our attorneys, and I'm very, very comfortable that we are moving in this direction. The taxpayers of Riverhead has spent a huge amount, thousands and thousands, over hundreds of thousands of dollars on trying to secure this property and move it forward, and unfortunately, it has not worked. We have also lost millions of dollars to our tax base, and we cannot address rumors and people's articles in newspapers and so-called attacks on the purchaser, the prospective purchaser. It's not in the contract. If it was in the contract, we can say, hey, based on your reputation, we can withdraw. We can't, unfortunately, legally, we can't address that. And I'm going to do everything in my power to ensure that those 1,000+ acres are preserved forever. It will be done through covenants. It will be done through aggressiveness, research with attorneys, and I'm sure every member here in this board agrees with me. And that is a goal. I inherited this contract. It was signed by my predecessor, and it's always been that elephant in the room, and hopefully that elephant is going to be shown the door, and we need to move this property, put the land back on the tax rolls, and ensure that the taxpayers are secure. This is one of the ways and avenues that we saw. We did not take it lightly. We had an open process. We had a open forum that was available through Zoom, in person, also taped on live on Channel 19. Channel 22. We've done everything we can to open this process. There was concerns concerning why a special meeting. This should have been voted on 2 weeks ago, and we just extended it, and the resolution immediately went up. It was always available. This is the way to go, and we as a board are going to continue, and we will be monitoring the IDA. I vote yes.
Resolution adopted.
Okay, we're going to now open it up for open comments on any other matter. Anyone care to comment? Good morning.
Good morning, dear. How are you? My name is Amanda Grams. I'm representing Sound Park Heights in Reeves Park. Thank you for going on the record about the 1,000 acres. It means a lot. First, I want to thank you all for your efforts on keeping Riverhead a wonderful place. One such thing is the no beach passes to non-residents. Another is the annual leaf pickup. Bringing back live nights in downtown, just to name a few, that keep Riverhead, Riverhead. But it puzzles me why you did not respond to a letter dated March 7th from 6 civic associations to ask for a moratorium on development while the comprehensive plan is being hashed out. That's 6 civic associations with thousands of resident votes behind them. That's 6 civic associations that pay full school tax, full garbage, full library, but many who are only summer residents. That's a bargain in my book. These are hardworking people. They're trying to maintain a way of life here. I ask you, why was there no response to this petition dated on March 7th? It had about 6 or 7 bullet points, which I have, and it was signed by every president of the civic associations asking for a moratorium until the comprehensive plan was hashed out. Is there anyone here who would like to answer?
I will simply state that I am not in favor of a full moratorium. It serves no purpose at this point in time. We're in the middle of a comprehensive plan. And things that are deemed as they are now, such as industrial As and industrial Cs, if those need to be changed, they will be done through the comprehensive plan. I would entertain if you have specifics that you want to talk about, such as solar, where we did put a moratorium on solar. But to put a blanket moratorium, no. No, I don't think that's a wise decision. I certainly will entertain any specifics, though.
Ed?
I'm just going to say this, and I'll defer to our legal department. If anybody that has purchased land or has permits in, and you want a moratorium on it, the amount of lawsuits that would generate to the taxpayers would, and the time it would hold up, people have land rights, as you do. And I said this at a Jamesport Civic meeting. If somebody purchased 2 acres on the bay in Jamesport to build a house, and let's say they purchased it 2 years ago, we put a moratorium on that, and then the comprehensive plan said no more building on the water in South Jamesport, what is that person gonna do? What would you do? I know what I would do. I'd put a major lawsuit against the town. I don't know how many permits are in, and we're just gonna stop that process. And from a legal perspective, I think it leaves the town open to insurmountable amounts of lawsuits. And I couldn't, that's what, and to Tim's point, if you have something specific, that's something that we can look at.
No, I believe that, commercial landowners are taxpayers too, and they have a right to develop their land. And it's not our job to prevent them from developing their land, it's to make sure that things are done accordingly. And that's what the comprehensive plan does, it guides us in the future. But it's improper for us to sit here now and go, everyone that owns any land that's not currently developed or projects that are, about to go in the pipeline or are in there, that we're gonna stop you and prevent you. I don't think it's right and proper.
I wish I
They
got
are-
their tax breaks.
But they're taxpayers too, and they have a right to develop their land under the current town rules and regulations and zoning laws. And so it's not our job to prevent that. I mean, we look at the comprehensive plan, and that gives us guidance in the future. But, they've been paying taxes, it would be unfair, and I'm certain, as well as Councilman Kern said, it would open up a vast amount of legal issues and lawsuits to be filed against landowners to say that, how could you prevent me? I've been paying taxes, there's land, I own a commercial building in Wading River. The land next to me is been developed, it's been owned by, zoned for commercial, and that individual has a right to develop, when and if he decides to. And it's not for me to prevent that.
And I agree with my council mates. We cannot just randomly stop progress in Riverhead, immediately shut everything down. There is a process, there's a comprehensive process. We're in the middle of doing it. Right now, what takes precedence is the old comprehensive plan. And as long as any development is within that, those guidelines, we have a fiduciary responsibility as a board to ensure that we don't go outside of our responsibility just for development purposes. People purchase land, they have a right. When they purchased it, they researched it, they knew what it was zoned for, they knew what maybe they had, whether it's residential, commercial, they knew that they had a vision on it, and we can't randomly say, oh, we're starting a plan that might take a year, and you can't do anything with that. And I agree with my councilman mates, and especially Tim Hubbard. If you had anything specific, please bring it forward. We
I
will
shall.
talk to you.
I shall.
Absolutely.
Thank you very much for your answers. I appreciate it.
All right. Thank you, Amanda.
Sid Bale, Wading River Civic. In 2003, I participated in the master plan process. And in reference to the comment, I think it was Councilman Kern made about moratoriums being illegal.
I didn't say they were illegal, I said it might cause some legal action to the town.
I agree.
to
I
clear
agree.
that up.
I agree with you there. So if you look back at 2003, where there were moratoriums, in fact, I can even go further back than that, 1987, when the Wading River Hamlet study was done, there were moratoriums. And particularly in 2003, if you go back and you look at the resolutions, there were all sorts of exceptions built into it, like you talked about someone who owned a 2-acre plot and wanted to build a house or something like that. Would they be impacted by the moratorium? And there were exceptions built into the moratorium resolution that was eventually adopted by the town board, and I think wisely so, because that would have generated, lawsuits. And as far as the idea, if someone has a permit, they're entitled to go ahead with the project, I believe the way it was couched in 2003 was if they had preliminary subdivision approval or final, I'm not sure, it was one or the others. But what I'm saying is, I don't have the actual legislation before me. There was attention paid to legal concerns, and as far as I know, it was a successful process. Permits. One thing that's kind of interesting, right, being involved in this master plan, is when we talk about future development in the town of Riverhead. I believe in 2003, the planning department put together a list of projects that had permits before the town right now, and what stage of development that they were in, et cetera. It would be extremely useful if the planning department would issue something like this, et cetera. And so just some views from my point. Thank you.
Appreciate that, thank you.
Thank you, Sid.
Sal.
Next.
Sid?
Just quickly on the subject of a moratorium, as many of you know, I was involved in the 2003 plan, and I can tell you that there is a legal way to impose a moratorium if you're at a certain point in time within the development of a comprehensive plan. At the time, we had extended moratorium. In fact, it was renewed several years. I think, Dawn, you were town attorney at the time. There were exemptions and exclusions to the residential moratorium, and it was a preliminary stage. Why do I bring this up? Well, the fact is, on commercial applications, and I'm not an attorney, but I know there is what is called vested. And just because someone makes an application, it doesn't mean they are vested in the zoning. You own property, you pay taxes, I agree with all of that, but in terms of enforcement of new zoning, if you are not currently vested in the zone that you're in, there is the law says that zoning can be changed. And in fact, we were challenged in several cases. And I know there were hybrid cases, and again, I'm a little bit out of my league, but I know we prevailed on the aspect of vesting property, and the town was able to enforce the new zoning, even though applications had been made for commercial projects. So, that's a little bit of history that may or may not be helpful to you. In terms of a specific request, I know I made a specific request at this podium early on, and in conjunction with the solar moratorium during that statement, and I can resend it to you if you'd like, but my concern was that that particular moratorium should be extended to include all industrial properties within the Calverton Hamlet outside of EPCAL. Right now, there are, and I'm sure Mr. Murphy has information about the hundreds of acres that are on the table right now for development in industrial properties in the hamlet of Calverton. Maybe that's one of those situations where we say, this all is happening here, do we need to rethink what uses may be allowed, what other alternative zonings, what other processes could be in place? That was a specific request. I believe it was reiterated by the Calverton Civic at some time thereafter. And to my knowledge, I never received an answer as to, whether the town board would be interested in pursuing that specific expansion of the moratorium. Thank you very much.
So Barbara, I just like to make a comment, because to your point, to do a blanket moratorium, it sounds like, and I would defer to Dawn, because she was involved in the process, if there was some specifics that, the town board could address, but I mean, to do a blanket moratorium, I just didn't
Well,
quite.
it wasn't, at the time, it was not a blanket moratorium back in 2003. It was very specific to residential upzoning. And in this case, what I'm suggesting is perhaps in the industrial zones, in the hamlet of Calverton. That's not blanket, that's fairly
No, I
specific.
understand yours,
Okay.
no, I
Thank
completely
you.
get you, and I appreciate it.
Okay, thank you,
Okay,
Councilman Curran.
thank you, Barbara. Phil?
Phil Barbado, just real quick, what we're saying is a focused moratorium. And I asked the question, how can we do an intelligent, comprehensive plan if we don't say, just time out for a minute here? Where are we going to have some development? Where do we not have development? Owning the property doesn't give you a right to develop it. I'm sorry. You're paying taxes on an undeveloped piece of land. So we need to just call time out for a short period, a focused moratorium that's very specific and has plenty of history behind it.
Phil, did you just say owning a piece of property doesn't give you the right to develop it?
It doesn't give you a specific right to do a certain development on that property. You can do it within the zoning.
We are
That's
going to
what-
definitely agree to disagree on that.
Well, that's what the application is. If you want to build something
You
on
can
your
pay
property.
taxes on it, but you can't develop it.
I didn't say you couldn't develop it. I said you couldn't develop it exactly in a certain way that you might want to. You have
If it's
to
zoned
make.
for it, you certainly
Yeah,
can.
you have the codes.
What is
If
it
it's zoned.
called when you apply for development to the planning department? What is that called, that application?
It depends.
Yeah, you need approval before you start building, don't you?
Well, typically, someone.
That's
will
what I'm
look
talking
at
about.
the
You may have
zoning.
misinterpreted
You
what
need
I
to
said.
approve a site plan on what you want
A
to do.
site plan application, you need a site plan approved.
And until it's approved, you don't have a vested right, as was
And it won't
mentioned.
get approved if it's not, if it's outside of the zoning. So if it's within the zoning, there is no reason to deny that application.
Correct.
Phil, let me
But
ask you a
until you
question.
make the application and it's approved, there's no vested right.
Phil, let me ask you, can I ask you a question? And I just want to, and I'm going to really, give you a whole different perspective. Let's say we did a moratorium, and we decided that, and the town decided, we want to go back to farmland. So anybody that wanted to sell their house couldn't, if they wanted to get out of their house, they can leave, and we're knocking down their house, and it's going to become farmland. I'm giving you a totally exaggerated perspective of this, in terms of your right as a homeowner. And this happened to the farms, didn't it?
The upzoning certainly happened to the farms in the
That
last,
happened in the
in
last
the
master
residential
plan.
zoning, yep.
I'm just giving you hypothetical, and I'm not opposed to, I don't think anybody is, like with the solar, it was very specific, can we get a moratorium in these areas? It was very specific, and the town board voted for it. It's very difficult to say, we just want a moratorium in Riverhead.
And we had to exempt the projects that are already in progress. And at that time, we had no other new projects coming in, and it was the most effective way of addressing that at that time.
Yes, I think that's what we're saying here. This can be a focused moratorium. It's not a blanket. You keep saying that. It's not a blanket moratorium we're asking
In that letter,
for.
there was nothing focused on in that request. It was just, can we do a moratorium until the comp
On
plan is
all
done?
development.
So, okay, so you reject the entire idea because it wasn't
I'm not
specific
rejecting
enough?
anything. You're
All
saying-
we're saying is, do a focused moratorium, stop the complicated actions that are going on now, so you can do a comprehensive plan. You can do it intelligently. If you don't know what development is being approved and where, how can you do a comprehensive plan properly?
The applications are in.
Yeah. Are they being taken
Well,
into
and
consideration in the comprehensive
same
plan?
people who review the applications
Absolutely.
are in charge of are charged with helping create the comprehensive plan. So it is focused.
Good, I'm glad.
And the comprehensive plan is still in the stage of gathering the information. It hasn't been put together to formulate exactly what's going to affect Industrial A, Industrial C, and the Calverton area. That point hasn't been reached yet.
Okay, but if you don't stop the buses now, you'll never reach that point of, okay, we have all the information. That's all we're asking for.
I
A
completely
focused
disagree with that
moratorium.
statement.
Hold it right now. Let's do an analysis of what's on the books already applied for, and do a comprehensive plan on that. That's all.
Anyone else?
John McCullough from Roanoke Landing again. I want to come back to the earlier business in response to some of the comments made. I think it should be clear that we're not in principle opposed to this transfer that you've now authorized, but we do think that there are serious questions, including the presumption that it will lead to necessarily a rapid development of it, or a rapid answer to the question. And it would be a rapid answer if the IDA decides that they are not financially qualified, or hopefully if it also looks at the credibility, the moral credibility of the presumed purchaser. That could resolve things quickly, and that, if that's provided you with the legal protection to be able to do that, then fine.
John, that's exactly what it's,
Okay,
the
then
way it's
that's
written.
great. I would,
There will be a process
right,
of vetting financially CAT.
right. But
And they are aware, and it's another avenue, it's a safeguard for us.
Right. So that part of it, but I think, again, if you look at the language, there's some things, and they may not be correctable, but we're puzzled why, and 5 minutes is 5 minutes, so I didn't bring it up before, the language in the whereas clause about CAT diligently pursuing the approval. Diligently pursuing means nothing. It's a very subjective term. There should be some time frame put into that so that we're not in a situation of which it has gone through and the property has been transferred. I mean, the confusion of the transfer and the leasing and the money being paid, and then what happens if, in fact, the various issues that have been brought up by DEC do not get resolved. So I think some real timeframes have to be written into it. The other thing which is puzzling, and maybe there's a legal logic to it, is in the whereas clause where it says that such 1,000 plus acres of undeveloped land are subject to the lease and project agreement, the public access. The public access to such 1,000 plus acres of undeveloped shall be subject to restrictions set forth in the lease and project agreement. We're not, again, what does that mean? Does that mean that during the lease period that the public cannot access those 1,000 acres if the Jamasians, for some reason, want to put that restriction in? Does it mean that after the land is actually, if the deal goes through, does that mean that they can decide that these 1,000 acres are off limits? They can put a fence around it, and we can see that lovely land there, and the habitat, the animals and the bugs and everything else will be protected, but the people of Riverhead won't be able to access that land. So I think that question of exactly what it means to have that land, again, I wish that you had simply taken it out of the whole deal, but at any rate, those are just the two clarifications. I think we also would love to know what it was that you held up the deal on and whether the language was changed, in what way the language was changed to satisfy you.
John, you raised some very good points, and that matter will be taken up with the IDA. And that's there will be covenants and certain restrictions and certain protections and that will be developed through the IDA.
I'll also just say, in terms of, part of the battle of, I believe that we're not gonna get our subdivision is because of the water supply up there and who's gonna provide it. But if CAT is developing the property, they're gonna put water in place. And so they pay for the infrastructure and Riverhead installs the water, provides them. It's a less battle to go back to the DEC and say, hey, guess what? We already have water, so why are you not allowing us, to subdivide this property? We're not gonna put the water in place for something that's not developed. So they have a much better opportunity to get the subdivision than we do.
And they can advocate. They can advocate in Albany, and municipalities don't. And this is a town-owned property, and so I totally agree with you. Amanda?
Thank you.
Okay.
Just one more comment.
Sure.
What is the response time to letters given to the board on any topic? Is it, you all consult each, can you give us a little background? Because quite frankly, a lot of the civic associations, when they write to you, they're not getting responses. And I thought that was kind of odd. You want to have a great dialogue with all of them, and yet it's not happening. Can you just give me a little roundabout about that? What is a timely fashion? Why don't you respond?
Well, if I get a letter, and sometimes the responses, like that particular letter, you have to inquire. We know it's going to be brought up here.
Right.
Like it was now.
Right.
So if it's a legal matter, I usually refer it to the attorney's office to answer out. If it's a personnel matter, I usually send it out to them. This was a very broad letter, and we knew you were going to bring it up, or somebody was going to bring it up, and it's out in the open, where we stand.
I try to respond to letters, but I also say that, when you set something forth, you have to give an opportunity. Certain things are discussed here in an open forum, but we are, we can't sit, the five of us individually with open meeting laws, and discuss how to proceed or how to address a letter when you address something to all of us as a whole party unit. It's difficult to respond to that.
But nonetheless, it should be.
Yep, but I
It should
think
be.
you have to get a general understanding. Sometimes you do want to consult with your fellow councilmates and the supervisor to get a better understanding of what and how to address that.
So does that
That letter was very just a blanket of, are you going to stop everything? And I don't,
But it's not the only letter. I think there's been a habit here where non-responses, that's it. And that's just to be brought up later at a mic and then discussed again, where it's getting a little frustrated. I could tell the people involved are saying our letters or our comments are falling on deaf ears, and truly, we are the community, and we just like some gentle response to our letters when they're sent to you.
I can answer for, I did speak with the Jamesport Civics the other day, and this topic came up, and I know that this letter was signed by all the civics,
Yes.
right? And one of the comments that I did make was that I would have to check with the legal department in terms of doing this blanket, stoppage. And I'll tell you that, I'm not in favor of the last comp plan. They devalued farms. I mean, they cut the value of farms in half, right? They didn't look at what other towns disallow. We became the shopping center for the East End. I don't know if you're happy about that, but I'm not. So I think that we have to be real serious in how we look at this comprehensive plan. In addition to my other comments, the questions that I was asked at the Jamesport Civic, I'm now working on 4 different things with several different departments in the town to give them solid answers and to get things done.
That's
So,
wonderful.
I just want to be real
That's like
clear
a
about that.
turnkey operation where you get to talk to your supervisors and board and you get some answers.
We're all available. I mean, anybody that gets in touch with me, I act on it. You
Well,
know,
I'm sure
I don't.
James Port appreciated you coming down to the meeting.
No, it's a pleasure.
Thank you for answering my questions, I appreciate it.
What I'll say is, to my knowledge, there's no specific policy as to how the town board individually or collectively responds to letters. Obviously, them being 5 different people could each respond to a letter in a different way. So. you
But I
know,
understand
I would-
time. I understand time to get together and have a cohesive answer, but
Yeah, but you
respond.
might not get a cohesive answer. You know, you could get 3 different responses. It's, you know, if that's something that the town board is interested in, you know,
The
discussing
difference
a
is
policy on,
if
we
you
can.
want, if, I do respond to, I get phone messages, or I will call everybody back. I get emails. I will say that sometimes I get a form letter that's sent by email, that's, 30 different people all using the
Sure.
same form letter, and I think
Sure.
that it's easier to address this in a forum like this. But when you're asking something that, a direct letter to each individual one, I would certainly respond to, but I don't feel that I should be responding on behalf of a board. When you put a letter addressed to the entire board, because my view might not represent the entire board. So I wouldn't say, we feel this way, or we're gonna go that way. That's not, when you're addressing the board, I think it's too generalized of a statement. But if you want to say, Councilman Rothwell, how do you feel individually about a moratorium? You'll get an individual response from me.
Thank you. And thank you, Mr. Howard, for your answer legally.
You're welcome.
5 seconds. That could be the opportunity at a work session. That could be something that the board collectively could say, we have an opinion, we don't have an opinion as to how to respond. It's something that could appear as unfinished business at a work session if you chose to address it that way. And Mr. Kern, I'd really like to make an appointment to discuss some of the concerns you had about the last comp plan, and perhaps some misinformation that we both may be,
Absolutely.
because
Anytime.
the entire town was upzoned. It was not just the farmers, and I know I've had this conversation with Mr. Councilman Bayrod as well. And part of why the commercial corridor was developed and is being developed the way it is because it's a receiving area for transfer development rights from the farmland. So it's all a balance. You can't look at things independently, but I'd love a further conversation with
I
you.
would
That
love
would be
it.
great.
Thank
Thank
you.
you very much. I appreciate it.
Great, perfect.
Except the farmers were never made whole by that. Never, ever, not even close. The TDR program did not ever repay the farmers in the way it should have.
Anyone else? You have 2 people? Okay.
Hello there. Buckley Turchin, Greater Calverton Civic. Are you able to hear me?
Yes.
Ah, terrific. Could someone clarify? I spoke at your, the previous meeting when I was on. Were you able to understand what I read into the record?
Yes.
Okay, I didn't know if I needed to repeat it. So, I'd like to echo what Sid Vale brought up, the president of Wading River Civic. It would be very helpful not only to residents, but also to this process right now for the comprehensive plan, and also to the town board, that the planning department create an inventory list of applications right now, then going forward, add to it. We don't know what's coming down the pike. So it would be nice to keep an updated inventory, just for general use, but certainly right now during the comprehensive plan. I also want to echo Barbara Blass's suggestion that during the work session is certainly an appropriate time for letters addressed to the board, to have that opportunity to listen to one another and to come up with a collective answer. And I understand that today would have been a work session had not this special meeting of CDA and town board taken place. And it would have been, today would have been an opportunity for the 5 of you to get together. And individual responses certainly are welcome to find people's individual council persons' perspectives. Mr. Kern, when I listened to you say you need to check with the legal department before answering portions of the correspondence you got. But it would seem it would be very prudent of you to do that before speaking to the Jamesport Civic, because then you could give a more complete answer on your individual perspective. I would ask that an opportunity be taken by the board to create a policy on when letters to the board are received by email, that you give us a resolution that says, hey, it's going to be a certain turnaround time, with reasonableness. You know, a 30-day turnaround time isn't reasonable, but something short of that, so that we're not depending on coming into public meetings and having to read these things into the record. Don't depend on us to do that, but how about we answer right up front, or the town board answer right up front, and certainly make use of a work session. But thank you very much for your time.
So Tiku, I just want to address, what you said, the agenda it was presented to me, I think, that morning or the day before, so I didn't have time to speak with the legal department. But I did tell them that I would follow up with the legal department.
No, oh, thank you. Oh, you didn't know you were going to speak? What you're saying is the agenda you got knowing that you were going to be a speaker?
I didn't know what was on the, I didn't know what was on the agenda.
Oh, the topic. Yeah.
Correct.
Well, I don't know. Thank you for that. I would anticipate that that's a hot topic. Certainly you know about the letter, and you're heading into a civic meeting, so that president signed that letter, so I'm certain that someone's going to ask you that question, whether it's on the agenda or not. It can come right off the floor. But I don't mean to pin you down. I really do want to see this facilitated with efficiency. Thank you so much.
Mr. Harari.
Good morning. Supervisor, in your statement regarding the vote on the resolution earlier, you indicated that you spoke with a very counsel on the matter. You stated that you also spoke with Council Gay. Is that right?
We can't hear you. You're coming in.
You broke up, Ron.
Can you hear me now?
A little better.
Earlier, Madam Supervisor, you indicated that with regard to the resolution, you conferred with council. Do you remember that?
All right, this is a comment section. I'll answer at the end, so go ahead. What is it? What is your comment?
You indicated specifically that you conferred with council to the IDA.
Mr. Harari, this isn't a give and take, okay? We welcome your comments. I'll respond at the end, okay?
Okay, allow me to continue, please. I assume when you indicated you spoke with counsel to the IDA, you spoke with William Ware of the law firm Nixon Peabody, who is counsel to the IDA. I wonder, madam, whether he made you aware that the law firm of Nixon Peabody is currently, through its partner Daniel Schnapp, representing the plaintiff in the lawsuit Red Rock Sourcing LLC v. JGX LLC et al., in which the plaintiff alleges that the defendants, including David Gramazian, Eli Berkowitz, and 555 Worldwide LLC, have engaged in a racketeering enterprise involving the sale of fake sanitizer. And I'm wondering whether or not counsel made you aware that earlier this month, Nixon Peabody wrote to Judge John Cronan of the Southern District in that case, alleging that the defendants have engaged in, and I'm going to quote from the letter from Nixon Peabody, apparent spoliation evidence in advance of plaintiff's application for a forensic examination of these defendants' electronic files. Perhaps you can comment, Madam Supervisor, on whether counsel advised you whether, should it be determined that these defendants are indeed a racketeering enterprise alleged by Nixon Peabody or have engaged in spoliation of evidence, how in the world they can be deemed qualified and eligible to purchase land from the town of Riverhead.
So, Mr. Herrera, I'm going to recommend to the supervisor that she not discuss the substance of any personal communications that she's had with any legal counsel. And I would advise her not to comment on allegations in a lawsuit that's not related to the town of Riverhead, especially, without knowing the facts and circumstances of the case top to bottom. I don't think it would be advisable to make any comment on that.
Well, except that the parties are affiliates of the applicant in the transaction with the town of Riverhead.
Well, Mr. Hurry, if your observations of the case bring what you believe to be relevant information that the town board should be advised of, you're certainly free to put that into a letter or an email and advise the town board of that. They can take that into consideration on future decisions.
My question, counsel, is the supervisor has previously stated that the town will undertake a detailed analysis of the financial ability of the applicant at the closing. And earlier today, she indicated that the town has no legal authority to investigate allegations or charges regarding this applicant appearing in the press. Can you tell me, as counsel, what the legal basis for that conclusion is?
Well, first, you're at the 5-minute mark, but two, I'm not totally sure I understand your question or all the subparts of it. You want to know what the town board should consider in connection with other allegations made against some part of this or one of the members of this company in a separate action?
The supervisor just said that she does not have the authority to review charges or allegations or press reports regarding, among other things, the financial condition of the...
So what I think the supervisor is probably driving at is just the authority to determine whether those are substantive or provable or credible allegations in the first place. That's not the role of a town supervisor. That's the judge who's overseeing that case.
I'm asking whether or not the town has authority to review report of, among other things, financial stress of this applicant. Would you concede that it does? As the supervisor has already repeatedly stated that the town will review the financial wherewithal of this applicant prior to closing. Does the town have that authority?
I think what the town's going to do in terms of a review of financials is already stated in the contract and then reiterated in this resolution that we're doing. And that's going to be the subject or the extent of the financial review. And it's designed by our counsel who worked on the contract and on these resolutions. It's designed to provide a level of comfort to deem, to say that they can actually proceed with the project that they're proposing. So
Okay.
thank you for your comments, Mr. Herrera.
Next question?
Next caller.
Yeah, next caller? Yeah, thank you. You have anyone? Oh, that's it? Anyone from the audience want to come forward? one? Okay, thank you, everyone. I'm going to ask for a first and a second to close the special town board meeting and open the special CDA meeting for the consideration of the exact same resolution that we just voted on. Dawn, can you please come forward? Good morning, Dawn.
Good morning, Board. How is everyone?
I'll make a motion.
Second.
Okay. Vote, please.
Kern.
Yes.
Rothwell.
Yes.
Baylock.
Yes.
Hubbard.
Yes.
Aguiar.
Yes.
The town board meeting is closed and the CDA meeting is now open.
So we would have a comment on the pending resolution on our agenda. So if there's any comments on CDA Resolution 2022-4, the board would entertain them.
Okay, any comments?
Phil Barbato, very simply, based on all the comments that were given to the town board on the weak writing and the wishy-washy sentences in the agreement and in the letter agreement, we ask that this be delayed and that those points be clarified and improved to protect the rights of the town of Riverhead properly and to make sure this deal gets done the way it should, the way you obviously intended to go. There's just too many weaknesses in there, and they need to be patched up. Thank you.
So if I could respond to that. So we've had Frank Eisler and Ms. Prudenti from the town attorney's office working on this, and they went through several drafts of this and multiple telephone calls back and forth with counsel for CAT. And they would not be recommending this resolution if they weren't comfortable with the terms that they've agreed on and those being actionable terms going forward.
Okay. Any
And
other?
I have complete faith in them.
Many hours, many hours, many meetings,
Ditto to that.
yeah, to get
Put
to
my
this
coat
point.
on. I thought I was on my way out the door, but just respectfully, I'm just wondering if it's possible, and if so, would the board be willing to transfer or incorporate the comments from the town board resolution that were relevant to this resolution into the official CDA record, rather than having to repeat all those
Yes, I agree with
comments?
that.
Thank you. Thank you
I'm
very
not
much.
sure, we have to check with the CDA director.
Okay, thank you very
Because it's a
much.
separate meeting, and we'll make sure that,
Okay, well, I would respectfully request then my
Okay, well,
comments
look,
be
yeah.
be
Just
made,
attach
and I'm
the
sure
minutes.
on behalf of the others. I don't know if that's possible or not, but
That's
thank you
okay?
very much. I appreciate it.
all right, great.
John McAuliffe, Rolling Woods. Mr. Howard essentially says this is the product of the two attorneys, and that ends the discussion. I hope
It
that,
doesn't tell me, I'm not saying it ends the discussion. I'm saying that we have two very competent attorneys who've been working on this for well over a month, who wouldn't be recommending this to the town board if they didn't feel comfortable with the final language that they've come up
well,
with.
they're human beings. Human beings can see things one way when they're just talking among peers who have certain assumptions about what language means. And it's been clear from the comments that have been made at this meeting that, now maybe we are all simply lay people and dumb clucks and don't understand it, but I think given the history of this particular deal with a very, as everybody agrees, a disastrously faulty contract that was written by the purchaser that disadvantaged the town, I think that you ought to have not assumed that the process that's already happened between the two attorneys, with Mr. Eisler having been part and parcel of the earlier faulty documents, I think you should not assume that you have not heard things that lead you or lead them to seriously to make a few changes in the actual language before it
think-
goes forward. I don't see the disadvantage of this holding up until the next board meeting to clarify the language that I've raised and others have raised to try to perfect it. I mean, what you're talking about 10 days
What a-
and maybe a better document. What's wrong with that?
What I would say is that there has been tremendous volume of public discourse on this transaction from 2017 until now. And so I would say that Ms. Prudenti and Mr. Eisler are well aware of the community's broader concerns regarding the applicant, their financial wherewithal, and any other, legal issues or, beliefs that may be brought up by the public. So I wouldn't say that in your comments that you should discount that they didn't think of those things while they were coming up with the language in this resolution.
Maybe they did, maybe they didn't. The point is that you've heard other ideas today that go to the substance of, they're not the whole concept of it, but would require a few hours of perfection of the language that would protect the town, that would put time frames around it, that would not have us in a situation where the Jermasians essentially have played another game with the town that will keep us in an unresolved process of really having development on the land. All we're saying is wait till the next board meeting to come back with perfected language. I don't see, unless you're simply assuming that this has all been a nice show and tell, that people have had a chance to vent their opinion again.
Well, I think I understand that point of it, and I also know the amount of work that Frank and Anne Marie put into this. So, again, if they are comfortable recommending this to the town board, at this point, it's up to the town board whether they want to move forward. And
well-
I'm sure that they've all heard your comments today, too.
All right, but I think then it needs to be amended if these comments have any validity.
And
That's
I
all
would-
we're saying,
I would
is
defer
make,
that to the town
make a
board's-
few
the town
changes
board's vote.
and bring it back to the next regular board meeting in April. That's all. I mean, why does this have to happen today? What is it that is militating
Just
on
as-
action
as-
today?
As a point of note, this was supposed to happen at the last town board meeting
And
last
you were
week.
totally
And it was-
unprepared
and it
at the
was-
last
and it-
board
and it-
meeting.
and
That's
it-
not,
it
that's
was-
not
it
true.
was-
That is
it was-
absolutely not
It was
correct.
adjourned to today so that all 5 town board members could be present to vote.
Well, that was in that particular meeting, yes, but in terms of, I'm sorry, I was thinking of the earlier meeting where it was postponed.
It was postponed.
Yeah,
because
no,
we weren't
but I'm
happy
saying
with the
is,
terms, so we
what is
kept
the, I
negotiating.
understand, but this is a $40 million deal that is not just $40 million, but is potentially bringing into the town a major social and financial force, and where I think serious questions are raised about the content of this that could be corrected, and you could come back on I think April 5th is the next board meeting with a perfected.
I think if
agreement.
we did that, honestly, everyone would come in on April 5th and give us another reason to delay it.
Well,
So,
I
at
think
this
if you,
point, I'm going to suggest that the town board
why
can take
don't, why
up their
don't you
vote.
try it? Why don't you try listening to people and
Because
acting on it?
that's up to the board, Mr.
Because the legal
McAuliffe, and I
advice
don't
that I'm
think we're
giving
willing to
is
do
to
that.
proceed.
Okay, all right. But
And I'll tell you why. We have 2 very qualified attorneys that put this together, and we've had probably at least 3 or 4 other attorneys' eyes on this during the entire process. And I, for one, am willing to put my eggs in the basket of all those attorneys and not John McAuliffe's basket. Thank you. No disrespect, John, but they're attorneys, you're not. Thank you.
Okay, no, but I was not the only person speaking. And
They weren't attorneys
will-
either.
And
Thank
in
you.
addition, again, the question is, unless you think there's some specific problem with what was said in terms of content of the document, I mean, I would give them a chance to perfect it. That's all.
This was not, and I know, Eric, you're correct, they've been working hard on this for 1 month to put it forward,
Been
but the
well over a
research
month.
started back in June,
Yes.
okay? So it was a very lengthy process, and I reviewed many documents, and this is not an approach that's uncommon. It is a common approach when a municipality has a property to move it forward in this fashion. This is the fashion, the avenue we should have taken in the beginning. We can go back, we're trying to move forward, and this was not a light decision made. And the board looked at this, they spoke. Obviously, we can't speak together unless it's being taped on the open meetings, but individually, we have spoken, we have gone back and forth. A tremendous amount of time has been spent on this, and I am confident that this is going to help resolve this matter. Anyone else?
Yes, Ron Hariri. I'm a little bit confused because earlier I heard at least 5 members of the board assert that they were dissatisfied with the contract that council had negotiated, and unfortunately they inherited. Now, you're insisting that you're satisfied with this work product. For the record, I'd like to state that this resolution is procedurally and substantively defective, fails to properly articulate the transaction, fails to provide timely and proper notices, and fails to comply with the general municipal law. Should you proceed to act without authority, Altavarez, the resolution will be subject to challenge in court in an Article 78 proceeding as contrary to proper authority. Altavarez, and I firmly expect would be struck down. That being said,
Mr. Hariri.
That being said, I think that Mr. McAuliffe makes a very legitimate plea to you that perhaps you seek further assistance from many able and articulate members of the community that might assist you in drafting a more appropriate resolution to protect the town. Listening again to your dissatisfaction with the underlying contract and real questions about A, the integrity of this applicant, B, whether it even has articulated a plan development, and C, whether it has the financial ability to develop the property. And finally, I asked the community development director whether there was any evidence whatsoever. This last hearing for actually the informational meeting that the board saw fit to provide. I asked whether there was any evidence at all. Here today,
Ron, you're breaking up again. Ron, you're breaking up.
Okay. I asked this question again of the CDA director. I asked it at the informational meeting whether, as we sit here today, there is any evidence the board can justifiably rely on of this applicant's financial ability to proceed, particularly in light of the published reports throughout multiple media sources of serious financial trouble its applicants' affiliates have experienced. Thank you, and I invite your comments. And again, I invite you to reach out to the community to see whether we can work together to achieve a better document that might provide better protection for the town.
Okay, moving forward. Chip?
That's all.
That's it? Anyone from the audience? Okay. Dawn?
Okay. Clear my throat, it's a long title. CDA Resolution 2022-4, a resolution authorizing the Town of Riverhead Community Development Agency, CDA, to make joint application with Calverton Aviation and Technology, LLC, CAT, to the Town of Riverhead Industrial Development Agency, IDA, to transfer title to all of the acreage CDA owns at the Enterprise Park at Calverton, EPCAL, comprising approximately 2,100 acres, in order to facilitate the sale and transfer of approximately 1,643 plus or minus acres at EPCAL to Calverton Aviation and Technology LLC pursuant to a lease and project agreement by and between CAT and the IDA and consistent with the terms of the agreement of sale between CDA, Town of Riverhead, and CAT dated November 19th, 2018. Agreement. Except as amended and agreed to as set forth and reflected by the terms of this resolution and letter agreement between CDA, Town, and CAT, and agreement between CDA and IDA for transfer of remaining property. We need a motion and a second.
Motion?
Second.
Kern.
Vote, please.
Yes.
Rothwell.
Yes.
Bayrock.
Yes.
Hubbard.
Yes.
Aguirre.
Yes.
The resolution is adopted. We would now open it up to general comments from the public on any CDA matter. Oh, yes, and just consistent with Ms. Blass's request, I think it's appropriate that we incorporate the comments made at the town board meeting relative to this identical resolution in this meeting. I guess, do we need to do a reso? Do you want to have them resolve that, or no?
Just do a
No,
motion.
we can just,
Just do a
Great.
motion.
yeah,
I think
it's just an
that's fine.
administrative, yeah,
So the record
absolutely.
will-
And it'll go up online anyway, into the EPCAL folder,
Very good.
the comments. Absolutely. Thank you, Dawn.
I think, seeing
think-
no open public comments,
Anyone online?
we
Okay.
can close the CDA meeting and reopen the town board meeting?
Yes.
Just going to close, just going to close the CDA meeting?
I'll make a motion to close CDA meeting.
Second.
Okay, Kern,
Yes.
Rothwell.
Yes.
Bayrock.
Yes.
Hubbard.
Yes.
Aguirre.
Yes.
The CDA meeting is
It's
now closed. Thank you.
Great, thank you, Dawn, and everyone. This concludes our special town board meeting and the CDA meetings of today. Can I have a first and a second to close the town board meeting? Okay, you closed it, you agree? I'm just reading my moments. Shut that door.
We have executive